Mr. Meadows has a valid suit that raises substantial legal questions that has been properly filed and will be properly heard. The committee seems unwilling to acknowledge the due process considerations of the court system affords while simultaneously cheering on decisions from the very court system's ruling when it favors their political argument. And just finally, I would say this. You cannot in good faith assert just 12 days ago that Justice Clark should have went to court if he wasn't going to comply, and then today assert that Mr. Meadows cannot go to court if he doesn't comply. But that is exactly what's happening. No matter how much many of you want that to be different, the fact is this. The party issuing a subpoena is not the final determiner as to whether that subpoena is valid. And it doesn't matter if it's in Congress or a plaintiff in a divorce case in family court. And while that might screw up political timelines, it also ensures that the process is determined by a third party without any political skin in the game. And with that, I yield back.
Thank you. I have no questions. Mr. Cole.
I just want to thank the gentleman for his testimony, which is very consistent with what he delivered when he was here last week. I think he makes a really superb case, and I commend him for that. But I know we're on a tight timeline, Mr. Chairman, so I'll try to facilitate us getting to the floor as rapidly as we can. I know we all want to do that, so I will yield back.
That's why I love you. Mrs. Torres.
No questions.
Dr. Burgess.
I'm going to assist the ranking member in complying with the tight timeline. I yield back.
Anybody on our side want to say anything?
One thing.
Perlmutter?
I guess not.
Oh, no, you can. Yeah.
Just curious, Mr. Armstrong, Mr. Clark, in his most recent letter, said he's going to assert the Fifth Amendment. Any idea why Mr. Meadows hasn't suggested that?
I have no idea. I can't speculate.
I yield back.
Mr. Reschenthaler. Mr. Raskin.
Just 3 quick points in 60 seconds, and the gentleman can respond if he wants to. Number one, his entire argument was devoted to places where there might be some controversy around privilege, although I don't think that really exists, but fair enough. What about the 9,000 pages where any claim to privilege has clearly been waived and abrogated? Does the gentleman not think that the committee has the right to interview Mr. Meadows about all of these unprivileged documents that he voluntarily submitted to the committee? Number two, as opposed to the theory offered by the chair and the vice chair of the committee that Donald Trump's calling his book fake news was the precipitating factor of Mr. Meadows pulling the plug suddenly on his participation with the committee, you offer the suggestion that it was because he discovered suddenly, I think many weeks later, that his phone records were somehow at issue with the committee, but in fact, the committee's not going to get the substance of any communications. It's simply the records of calls having taken place, and I think the gentleman would agree that the Supreme Court has said that that is not material that's covered by Fifth Amendment privilege or Fourth Amendment, or that requires a subpoena. That's just an objective fact in the world whether calls took place. And finally, I think the gentleman has offered misplaced emphasis on the Mazars case, which deals with a situation where there's a conflict between the branches. Here, the two branches agree. President Biden has said for the executive branch, there's no executive privilege that's being asserted, and Congress agrees that this material is absolutely necessary. And of course, as you know, the DC Circuit found that not only was there no compelling interest to override the people's right to get this information, but Donald Trump didn't even offer one. I yield back to you, Madam Chair. Or if you have any comments.
I don't think it'd be a hearing, Mr. Raskin, if you and I had a little back and forth, unless you and I had a little back and forth on something. One, on the negotiation thing, I would say this. Negotiations are either completed or they're not. And I've read all of the correspondence, and I would actually contend that Mr. Meadows has worked very diligently to provide non-privileged information and has at least expressed viable options for dealing with the privilege issue. But you not reasonably expect somebody to show up in an adversarial position when you have essentially told them that you will ask them about what is being contended to be privileged in the middle of the non-privileged information. That is an unrealistic place to be. It is an unrealistic place to be in an adversarial deposition. And either negotiation is complete or not, and you just say, we're going to ask you about unprivileged information, but then we're going to ask you about information, and you do it line by line in an 8-hour adversarial position. With regards to the Verizon case, whether it's Fifth or Fourth Amendment implications, and I think this is something that we should be careful of just wholly regarding the whole investigation. This isn't a criminal case, and a criminal prosecution is not legitimate legislative purpose. And as we keep veering into those areas and mixing the grounds, listen, we are reading out of criminal statutes far too often in defense of this investigation. I have to remember that is specifically determined that a case is not a legislative purpose. And with regards to the privilege claim and conflicts between the two branches, Nick, we've talked about this before, and I'll be brief here, has asserted that former presidents have some right to executive privilege, and it's a totality of the circumstances. That's where, regardless of how this is going to be determined, the times aren't done in court. They just simply aren't. These cases are not finished yet. And so with that, I yield back.
Okay. I'll just say before yielding back to you, Madam Chair, as Mr. Morelli emphasized, if you agree that a certain category of subject is not privileged and you offer documents about it, that does not absolve you of your obligation to testify about it. People are called to produce documents, papers all the time and then testify about them, and a witness doesn't get to choose between them. I yield back to you.
Ms. Fischbach.
Thank you, Madam Chair. And Mr. Armstrong, you kind of, I think you were just getting into it, but just to be clear, criminal contempt is not subpoena enforcement, is it?
No.
And if the goal is to enforce the subpoena, what action would the majority, would the committee take to compel the information they seek?
Well, you can go to court. I would not pretend what they would think, but you can go to court to compel the information. But I will say this, once you go down the road of criminal contempt, the likelihood of obtaining any testimony at all is significant.
Well, and Mr. Armstrong, the question remains, as with the other resolutions that we dealt with, what legislative purpose or otherwise are they trying to reach with the subpoenas? And so would this resolution have in regard to the stated goals of the select committee?
Yeah, the legislative purpose question is, and that's what I was talking about, going back and forth and inferring criminal conduct, utilizing criminal statutes. That is not a clear, legitimate legislative purpose. It just simply isn't. It may be a great political purpose, but so I think, listen, I just think we should be a little careful about that in general.
Thank you, Mr. Armstrong, and I yield back, Madam Chair.
Ms. Scanlon.
Thank you, Madam Chair. There've just been a couple references suggesting that somehow it's too rushed to seek contempt at this point, or that there have been insufficient efforts to accommodate Mr. Meadows. I would just refer anyone who's interested in what's actually transpired to the Select Committee's report that was filed with the House yesterday, and pages 12 through 19 detail in excruciating detail the issuance of the subpoena 3 months ago and all of the back and forth and back and forth. It has not been a couple of letters. It has been intensive, and I think the Select Committee has gone well above and beyond any reasonable accommodation, and this just can't be dragged out forever. So with that, I yield back.
Mr. Morelli. Mr. Morelli. Mr. Saunier. Ms. Ross. Mr. Neguse. Does any other member of the committee wish to ask a question? Seeing none, I would like to thank our witness for their testimony. Please leave with our stenographer or submit electronically anything that you would like inserted into the record. You are now excused.
Are there any, there any other members who wish to testify on this resolution? Seeing none, this closes the hearing on the resolution. At this time, the chair will entertain a motion from the distinguished gentleman from Maryland, Mr. Raskin.
Mr. Chairman, I move the committee provide for consideration of the resolution accompanying House Report 117-216 under a closed rule. The rule provides that if House Report 117-216 is called up by direction of the Select Committee to investigate the January 6th attack on the United States Capitol, all points of order against the report shall be waived and it shall be considered as read. The rule provides 1 hour of debate equally divided among and controlled by Representative Thompson of Mississippi, Representative Cheney of Wyoming, and an opponent or their respective designees. The rule waives all points of order against consideration of the resolution accompanying the report. Finally, the rule provides that the resolution accompanying the report shall be considered as read.
You heard the motion from the gentleman from Maryland. Is there any amendment or discussion? Hearing none, the vote now is on the motion from the gentleman. All those in favor say aye. Aye. Opposed, no. Opinion of the chair, the ayes have it. A recorded vote has been requested. Clerk will call the roll.
Mrs. Torres. Aye. Mrs. Torres. Aye. Mr. Perlmutter.
Aye.
Mr. Perlmutter. Aye. Mr. Raskin.
Aye.
Mr. Raskin. Aye. Ms. Scanlon. Aye. Ms. Scanlon. Aye. Mr. Morelli.
Aye.
Mr. Morelli. Aye. Mr. DeSaulnier.
Aye.
Mr. DeSaulnier. Aye. Ms. Ross. Aye. Ms. Ross. Aye. Mr. Neguse. Mr. Cole.
No.
Mr. Cole. No. Mr. Burgess. No. Mr. Burgess. No. Mr. Reschendahler. Mr. Reschendahler. No. Mrs. Fishbach. Mrs. Fishbach. No. Mr. Chairman.
Aye.
Mr. Chairman. Aye.
Clerk report the total.
8 yeas, 4 nays.
Motion is agreed to. At this time, the chair will entertain a motion from the distinguished gentleman from California, Mrs. Torres.
Mr. Chairman, I move the committee grant H.R. 5665, the Combating International Islamophobia Act, a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Foreign Affairs or their designees. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 117-23 modified by the amendment printed in the Rules Committee report shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended, and finally, the rule provides one motion to recommit.
You heard the motion from the gentlewoman from California. Is there any amendment or discussion? Hearing none, the vote is on the motion from the gentlewoman from California. All those in favor say aye. Aye. All those opposed say no. No. Opinion of the chair, the ayes have it. Yeas and nays have been requested. Clerk will call the roll.
Mrs. Torres. Aye. Mrs. Torres. Aye. Mr. Perlmutter.
Aye.
Mr. Perlmutter. Aye. Mr. Raskin.
Aye.
Mr. Raskin. Aye. Ms. Scanlon. Aye. Ms. Scanlon. Aye. Mr. Morelli. Aye. Mr. Morelli. Aye. Mr. DeSaulnier.
Aye.
Mr. DeSaulnier. Aye. Ms. Ross. Aye. No. Mr. Chairman.
Aye.
Mr. Chairman. Aye.
Clerk report the total.
8 yeas, 4 nays.
The ayes have it. The motion is agreed to. I will carry this for the majority. Mr. Raskin will carry the contempt resolution for the majority. Yeah, and on your side.
Ms. Fishbach will carry the contempt resolution. Mr. Reschenthaler will carry the matter we just dealt with.
Okay, and the contempt resolution will be up at 12:15, I'm told. 12, I'm sorry, 12 sharp.
12:15, you guys show up at 12:15.
I just,
Yeah, they're going to be first.
just want to note for the record, we facilitated
You
this
did,
last
and I appreciate it. Yeah, so we're still waiting to figure out on the debt ceiling when the Senate's going to be done, but,
Good luck with that.
yeah. So it could be today, but if it is late into the night, I would prefer that we meet in the morning and do it tomorrow, but we will keep you apprised of what's going on over the Senate. All right, with that, all right, with that, the committee stands adjourned.